320. The rule reflects a belief that in the fair administration of justice, no man can be judge in his own case, no matter how exalted his station or righteous his motives. ID. At 320, 21, the Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath.
impeach.com. Another 2:30 a.m. quick video. I'm just popping on here to TikTok. If you want to watch the video that I'm talking about and you're watching this on TikTok, the video I'm going to be sharing on my YouTube channel, which is Cat Love Dreaming Peach. And this video is another AI voice reading two documents in this case. And some of the AI voice is actually me, because I created a AI version of my own voice. But some of it is in the AI voice called Lola. And these are premium voices on naturalreaders.com. And hold on, please hold. Okay, so the first document is a 7-page document. It is document number 88. This is the USCA4 Appeal 25-1404 Doc 8. This was filed yesterday, April 17th, 2025. It's 7 pages, and it is in reference, it's from the United States Court of Appeals for the 4th Circuit. Kilmar Armando Abrego Garcia, Jennifer Stefania Vasquez Sura, AAV, a minor, by and through his next friend and mother, Jennifer Vasquez Sura. Maybe that's supposed to be best friend. I don't know. Those are the plaintiffs, appellees versus Christy Nome, Todd Lyons, Kenneth Ginallo, Nikita Baker, Pamela Joe Bondi Bitch, and Marco Rubio. Okay, so that is read. It is an order by the Circuit Judge Wilkinson, with whom King and Thacker Circuit Judges join. Wilkinson, by the way, was appointed by Reagan in 1984 and used the word shocking in their order. The second motion that is read in this video is from JGG et al. Plaintiffs versus Donald J. Trump et al. And this is case 125-CV-00766-JEB, J-E-B. This is document 81, which was filed April 16th, 2025, and it's 46 pages. I actually started to listen to this while I was recording it, screen recording the text while listening to it. It was taking a long time and I had to go, and then when I got home, I saw the 7-page one, and I thought, you know what, let me put the 7 pages in front because it's a lot shorter. It's about 14 minutes of this video, and then the rest of the video is the other document by Judge. So let's see. So this document is James E. Boasberg, which is the Chief Judge, which is the JEB. Okay, and then the other document, let me go to the bottom. This is from, like I already said, Circuit Judges Wilkinson, King, and Thacker. So, also, there's now proof of life. Senator Chris Van Hollen actually finally got to see Kilmar. He tweeted I correct myself. He blue-skied. I said my main goal of this trip was to meet with Kilmar. Tonight I had that chance. I have called his wife Jennifer to pass along his message of love. I look forward to providing a full update upon my return. he's a hero. Okay? And let's see. These are other photos of them. Thank God he's alive. And as some of the lawyers I was watching pointed out, this only proves that he was actually able to be easily gotten out. And then this motherfucker, the president dictator of El Salvador, tried to fucking troll him saying, oh, he's miraculously arisen from the death camps and torture, now sipping margaritas with Senator Van Hollen in the tropical paradise of El Salvador. Really? He's drinking water, bitch, okay? And he should be sipping margaritas. Okay, so this is on MSNBC. And then he tweeted again, now that he's been confirmed healthy, he gets the honor of staying in Salvador's custody. But we'll see how long that's going to actually last. Okay. Also, it's dark in here because it's 2:30 in the morning. I don't feel like turning on the lights. But let me just make it clear. Anybody who believes that this man should stay in El Salvador or that it was the right thing, you're a fucking Nazi. Whether you know it or not. And at this point, nah, we're not going to say Nazi wannabes or Schmittlers or Schmatzis because you are fucking outright Nazis. And you're despicable and you're garbage. You're soulless. You are evil. You are the scum of the earth. And that's my uncensored opinion. And so I had been following Blake Lively, Justin Baldoni so passionately, and I am still following. I was watching The Tilted Lawyer tonight. He did a live stream. It was interesting. But I will be honest and say that as much as I still care about justice for Justin, this bullshit, this Nazi shit that's happening is dwarfing everything else to me. Because innocent people being scooped up, snatched, being abducted, being kidnapped, and sent to a foreign place. And, he had a court order of protection. There are lies that he's a gang member. There are lies that he abused his wife. There are lies that he's a criminal. Those are lies. There are lies, blatant fucking 1984 double speak, absolute, the opposite of what is true we're saying. Just like when he said he won the 2020 election and it was the absolute lie, which I also believe him winning the 2024 election is an absolute lie. That's my opinion. And which I believe is founded by the facts that I've watched on multiple channels. And look up Jessica Denson Lights Out if you want to find out more data about that. She posts about that. But I personally am getting to the feeling like he's not going to last 4 years. He's going to get impeached, but for real this time. And I feel like, I was doing some research. Okay, we need 4 congressmen, 4 Republican congressmen, and 20 senators. Or wait, is it the other way around? Let me see. All right, here's a chart. House impeachment, you need 217 votes, which means we only need 4 Republicans to switch sides, essentially to say, yes, let's impeach him. Then you need 67 votes from the Senate, so we need 20 of the GOP motherfucking bitches to switch over. So that could be harder, okay? But basically, here's some other graphs they did for me, which I didn't like as much. But it's showing how many we need of these Republicans to say, you know what, I am going to go ahead and vote to impeach this motherfucker, okay? So I tried to show a few different types to show what you actually need. Impeachment process visual guide. Step 1, House of Representatives vote to impeach. Total voting members 433 with 2 vacancies. You need 217 votes to impeach. So for Democrats, there's 213. Then we need 4. We only need 4 Republicans to reach 217. Okay, then once that happens, step 2, conviction vote. There's 100 members in the Senate. Votes needed to convict and remove 67. Okay, and so with Democrats plus independents who vote with Democrats, there's 47. There are 53 Republicans, and so in order to get that impeachment vote, you need 20 Republicans to switch to reach the 67. Now I'm scrolling down. Let's see. Okay, so here's a couple of more charts where you can see exactly this little line is how many. 4 needed. 4 Republicans to impeach him in the House, and then to convict, we need 20 Republicans to take the side and to say, fuck this bitch, fuck this Hitler wannabe. We don't like this guy at all anymore. You know, he's not doing us a good job. And here's another version, which I don't really see much of a difference between these two. But I think it's possible. I'm starting to think more than anything that could potentially really happen, because I just don't see how we can keep letting this lawless criminal destroy our country and destroy our relationships, destroy our economy, destroy the foundation of our Constitution, destroy people's rights, destroy birthright citizenship, destroy Social Security, destroy the trust, destroy everything, destroy the military, destroy classified documents, destroy everything that's been built up. And I feel like he's going to get impeached. But we'll see. Maybe I'm just Pollyanna wishful thinking. All right. Thank you for being here. And if you want to hear those 2 specific documents being read out, they're coming up next. Don't forget to hit like, share, subscribe. Please subscribe. It would really be great and helpful for me if you would help me grow my channel. I love you being here. I really appreciate you. I love it when you comment and ask questions and share your opinions. And maybe you didn't realize that you're not subscribed, so just click subscribe. It's free. However, if you would like to support me, you can join as a member, or you can join me on Patreon, and I will see you there in the next one. And enjoy this audio.
USCA 4 Appeal 25 to 1404 Doc 8 filed 04-1725 PG 1 of 7 Case 8 25 CV 0951 PX Document 88 filed 04-1725 Page 1 of Siled. April 17th, 2025 United States Court of Appeals for the 4th Circuit No. 25 to 1404 825 C00951 PX Kilmar Armando Abrego Garcia, Jennifer Stefania Vasquez Sura, AAV, a minor by and through his next friend and mother, Jennifer Vasquez Sura, plaintiffs appellees, Christy Noom, Todd Lawns, Kenneth Gianalo, Nikita Baker, Pamela Jo Bondi, Marco Rubio, defendants appellants. ORDER Wilkinson, circuit judge with whom King and Thacker circuit judges join. Upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. USCA 4 Appeal 25 to 1404 Doc 8 filed 04-1725 PG, 2 of 7 Case 8, 25 CV 00951, PX Document 88 filed 04-1725, page 2 of 7. It is difficult in some cases to get to the very heart of the matter, but in this case it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. See 8 CFR 20824F, requiring that the government prove by a preponderance of evidence that the alien is no longer entitled to a withholding of removal. Moreover, the government has conceded that Abrego Garcia was wrongly or mistakenly deported. Why then should it not make what was wrong, right? The Supreme Court's decision remains, as always, our guidepost. That decision rightly requires the lower four federal courts to give due regard for the deference owed to the executive branch in the conduct of foreign affairs. Noem versus Abrego Garcia, 24A 949, slip op at 2, U.S. April 10, 2025. See also United States v. Curtis Wright XP Corp., 299 U.S. 304, 319, 1936. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in 2 U.S.C.A. 4 appeal, 25 to 1404 Doc. 8 filed, 04-17-2025 PG, 3 of 7 Case 8, 25 CV 00951. PX Document 88, filed 4-1725, page 3 of 7, accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. The Supreme Court's decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Abrego Garcia supraslip op. 2. Facilitate is an active verb. It requires that steps be taken as the Supreme Court has made perfectly clear. See Abrego Garcia supraslip op. At 2. He government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. The plain and active meaning of the word cannot be diluted by its constriction, as the government would have it, to a narrow term of art. We are not bound in this context by a definition crafted by an administrative agency and contained in a mere policy directive. Cf. Loper-Bright enters. 5. Raimondo, 603 U.S. 369 400 2024. Christensen versus Harrison-Tai, 529 U.S. 576 587, 2000. Thus, the government's argument that all it must do is remove any domestic barriers to Abrego Garcia's return Mott for stay at 2 is not well taken in light of the Supreme Court's command that the government facilitate Abrego Garcia's release from custody in El Salvador. Facilitation does not permit the admittedly erroneous deportation of an individual to the one prisons that the withholding order forbids, and further, to do so in disregard of a court order that the government not so subtly spurns. Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to 4 and 3 U.S.C.A. 4 appeal. 25 to 1404 Doc 8 filed, 04-17-2025 PG, 4 of 7 Case 8, 25 CV 0951, PX Document 88, filed 4-17-25, page 4 of 7 detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasions have always stood. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear. Court rulings are not above criticism. Criticism keeps us on our toes and helps us do a better job. C. Cooper versus Aaron, 358 U.S. 1, 24, 1958. Frankfurter, J. Concurring. Criticism need not be stilled. Active obstruction or defiance is barred. Court rulings can overstep, and they can further intrude upon the prerogatives of other branches. Courts thus speak with the knowledge of their imperfections, but also with a sense that they instill a fidelity to law that would be sorely missed in their absence. Energy in the executive is much to be respected. Federalist No. 70 at 423, 1789. Alexander Hamilton, Clinton Rossiter ed. 1961. It can rescue government from its lassitude and recalibrate imbalances too long left unexamined. The knowledge that executive energy is a perishable quality understandably breeds impatience with the courts. Courts, in turn, are frequently attuned to caution and are often uneasy with the executive branch's breakneck pace. And the differences do not end there. The executive is inherently focused upon ends, the judiciary much more so upon means. Ends are bestowed on the executive by electoral outcomes. Means are entrusted to all of government, but most especially to the judiciary by the Constitution itself. 4 U.S.C.A. for appeal, 25 to 1404 Doc. 8 filed, 04-17-2025 PG, 5 of 7 Case 8, 25 CV 00951, PX Document 88 filed 04-17-25, page 5. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process, and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to take care that the laws be faithfully executed would lose its meaning. U.S. Const. Art. 3, see also ID. Art. 2, 1 late. Today, both the United States and the El Salvadoran governments disclaim any authority and or responsibility to return Abrego Garcia. See President Trump participates in a bilateral meeting with the President of El Salvador, White House, APR. 14, 2025. We are told that neither government has the power to act. The result will be to leave matters generally, and Abrego Garcia specifically, in an interminable limbo without recourse to law of any sort. The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today, this has not been the case, as calls for impeachment of judges for decisions the executive disfavors and exhortations to disregard court orders sadly illustrate. See, e.g. Michelle Stoddart, Homegrowns are next. Trump doubles down on sending American criminals to foreign prisons. ABC News, APR. 14, 2025, 6:04 p.m. David Rutz, Trump open to sending violent American criminals to El Salvador prisons. Fox News, APAR. 15, 2025, 11:01 a.m. Eastern Daylight Time. 5 U.S.C.A. for appeal, 25 to 1404 Doc. 8 filed, 04-17-2025 PG, 6 of 7 Case 8, 25 CV 0951, PX Document 88 filed 04-17-25, page 6 of 7. It is in this atmosphere that we are reminded of President Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown v. Board of Education 2 to desegregate schools with all deliberate speed. Address by the President of the United States, delivered from his office at the White House 1-2, Sept. 24, 1957, 349 U.S. 294, 301, 1955. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the President and the executive branch of government will support ensure the carrying out of the decisions of the federal courts. At 3, indeed in our late executive's own words, unless the president did so, anarchy would result. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis, but it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. 6 USCA for Appeal, 25 to 1404 Doc, 8 filed 04-1725 PG, 7 of 7 Case 8, 25 CV0951, PX Document 88, filed 04-1725 page 7 of 7 in sum, and for the reasons foregoing, we deny the motion for the stay pending appeal and the writ of mandamus in this case. It is so ordered for the Courts Nwamakanoe Clerk.
Memorandum Opinion on the evening of Saturday, March 15th, 2025. This court issued a written temporary restraining order barring the government from transferring certain individuals into foreign custody, pursuant to the Alien Enemies Act. At the time the order issued, those individuals were on planes being flown overseas, having been spirited out of the United States by the government before they could vindicate their due process rights by contesting their removability in a federal court, as the law requires. Trump v. JGG 2025 WL102 for 097 at 2, U.S. April 7th, 2025, per curiam. Rather than comply with the court's order, the government continued the hurried removal operation. Early on Sunday morning, hours after the order issued, it transferred 2 plane loads of passengers protected by the TRO into a Salvadoran mega prison. As this opinion will detail, the court ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. The court does not reach such conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses has been satisfactory. 1 case 1:25 CV 00766 JB document 81 filed 04-16-25 page 2 of 46. One might nonetheless ask how this inquiry into compliance is able to proceed at all given that the Supreme Court vacated the TRO. After the events in question, that court's later determination that the TRO suffered from a legal defect, however, does not excuse the government's violation. Instead, it is a foundational legal precept that every judicial order must be obeyed, no matter how erroneous it may be, until a court reverses it. Walker v. City of Birmingham, 388 U.S. 307, 314, 1967. If a party chooses to disobey the order, rather than wait for it to be reversed through the judicial process, such disobedience is punishable as contempt, notwithstanding any later revealed deficiencies in the order. CID at 314 na 320. That foundational rule of law answers not just how this compliance inquiry can proceed, but why it must. CID at 320. The rule reflects a belief that in the fair administration of justice no man can be judge in his own case, no matter how exalted his station or righteous his motives. ID. At 320:21, the Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. To permit such officials to freely annul the judgments of the courts of the United States would not just destroy the rights acquired under those judgments. It would make a solemn mockery of the Constitution itself. United States v. Peters 9 U.S. 5 Cranch, 115, 136, 1809, Marshall, C.J. So fatal result must be deprecated by all. ID. I. Background. A. Factual background. As just noted, the injunction in question was issued on the evening of Saturday, March 15th. A day of events that moved at breakneck speed because of the government's apparent effort to remove individuals more quickly than the judicial proceedings in which it was actively to case 1. 25 CV 00766, JB document 81 filed 0416 25 page, 3 of 46 participating, could keep pace. See generally JGGV, Trump 2025 WL890401 at 135 DDC March 24th, 2025. The day prior, the president had seemingly signed, but not yet made public, a proclamation invoking the Alien Enemies Act. C90 Federal Reg 13033, March 14th, 2025. Through that 1798 Act, Congress granted the president broad authority if there is a declared war with a foreign nation or government, or if a foreign government has perpetrated, attempted, or threatened an invasion or predatory incursion against the territory of the United States. 50 U.S.C. 21. In such a scenario, and if the president makes public proclamation of the event, he is authorized to apprehend, restrain, secure, and remove any natives, citizens, denizens, or subjects of the hostile nation or government who are 14 years or older. CID. In his proclamation, President Trump announced that the government would use the Act's authorities to apprehend and remove members of Tren de Aragua, a violent Venezuelan transnational gang that had recently been designated a foreign terrorist organization. C90 Federal Reg at 13033. To support that finding, the president asserted that the Venezuelan government of Nicolas Maduro indirectly relies on Tren de Aragua and has been infiltrated by the gang. ID. He further announced that Tren de Aragua had committed or attempted an invasion or predatory incursion upon the United States, including through drug trafficking, mass illegal migration, and irregular warfare, though he provided no examples of the last. ID. Although the proclamation was not published until 3:53 p.m. on Saturday, CECF no. 28-1 Robert L. Cerna Second Deco. 5. Defendants had begun setting act-based removals into motion weeks earlier. Beginning in early March, the government interrogated Venezuelans in its custody about alleged membership in Tren de Aragua and transferred many of those it deemed 3 Case 1. 25 CV 00766, JB document 81 filed 0416 25 page, for 46 gang members to El Valle Detention Facility, located outside Harlingen, Texas, not far from the Mexico border. The reason for staging them together at El Valle became clear on Saturday. Early that morning, when the signed proclamation was still hours from being disclosed to the public, the government reportedly loaded scores of Venezuelans onto buses, drove them to a nearby airport, and began putting them onto 3 planes. See ECF numbers 44-9, Karen and Shirley Second Deco, 3-9, 44-10, Stephanie Quintero Deco, 3-4, 44-11, Grace Carney Third Deco, 11-13, 44-12, Melissa Smith Deco, 11-14, see also ECF no. 76, April 3rd, HRG TR. At 9, Government Counsel agreeing defendants were acting in preparation of the proclamation before it was posted. As the plane sat on the tarmac, officials refused to answer the deportees' questions about where they would be taken. See Shirley Second Deco, 10, Carney Third Deco, 12. Among those queued on the tarmac or placed onto planes that morning were the 5 plaintiffs in this lawsuit. Apparently catching wind of the impending proclamation, they filed suit at 1:12 a.m. on Saturday, before the buses left El Valle, and then moved for a TRO preventing their removal under the proclamation. In addition to asserting that the proclamation lacks a legal foundation, each plaintiff adamantly denies that he is even a member of Tren de Aragua. See Shirley Second Deco, 4 JGO, Carney Third Deco, 3 GFF, ECF NOS. Viens Champo, Deving desmit dupasmit a gig a Tries means seshi egg detsu. Dupasmit tries means astoni a detsu. Piektais. Around 8 a.m., this court learned that it had drawn the case through the court's random assignment system. Chambers then reached out to locate government counsel. Less than an hour later, plaintiff's counsel informed Chambers that at least one plaintiff was reportedly already aboard a removal flight. Having not yet heard from the government, and given the exigent circumstances prompting the need to freeze and place the status quo until a hearing for Case 1. 25 CV 00766, JEB Document 81 filed 04/16/25, page 5 of 46, could be held. The court entered an ex parte TRO preventing defendants from removing the 5 plaintiffs for 14 days. See Minute Order of March 15th, 9:40 a.m. Not long after the TRO issued at 9:40 a.m., government counsel informed Chambers by email that the TRO had been disseminated to the relevant executive branch agencies. Sure enough, several of the named plaintiffs report that they were abruptly removed from planes. See Shealy Second Deckel, 11, Carney Deckel, 13, Smith Deckel, 14. Evidence that defendants were able, if they wished, to ensure that people on the ground knew relatively quickly of developments in the court proceedings. See also ECF number 20, March 15th, HRG. TR. At 5, government stating on Saturday evening that relevant agencies had confirmed named plaintiffs were not to be removed. At 10:15 a.m., in an email thread including Chambers and counsel for both sides, plaintiffs asked the court to hold an emergency hearing on their pending request to provisionally certify a class, comprising them and those similarly situated, and issue a second TRO covering the whole class. The government objected that a broader injunction and a hearing on the issue would be premature, and it asked the court to wait until Monday for a hearing. The government notably did not respond to plaintiffs' pointed question about whether it was prepared to halt removals pursuant to the act in the interim. So, just after 11 a.m., the court set an emergency hearing for 5 p.m. that same afternoon. Shortly after the proclamation appeared on the White House website at 3:53 p.m., and about 45 minutes before the hearing began, plaintiffs' counsel informed Chambers that he believed that 2 flights, both operated by a contractor used by Immigrations and Customs Enforcement for deportations, were scheduled to depart Harlingen that afternoon. Counsel expressed concern that the flights might imminently take off with his 5 clients and members of the potential class on board. The government again offered no response. 5 Case 1:25 CV 00766, JB Document 81 filed 04/16/25, page 6 of 46 in the 5 p.m. hearing. The court clarified the limited scope of the TRO then in place. See March 15th HRG. TR. At 3, and turned to whether it should provisionally certify the class. ID at 56. The government began by objecting that venue was improper because plaintiffs' claims could be raised only through a petition for habeas corpus in the federal district in Texas where they were being held, not in the District of Columbia. ID at 6. 11, noting that it would benefit from further argument on the issue, the court pivoted to addressing plaintiffs' concerns about imminent deportation. ID. At 11, it asked the government point blank whether there were any removals under this proclamation planned. In the next 24 or 48 hours, ID. Government counsel said that he did not know, but that he could investigate and report back. ID plaintiff's counsel then interjected that various sources had informed him that the 2 removal flights that were scheduled to depart that afternoon may have already taken off, including during this hearing. ID. At 12. So, at 5:22 p.m., the court adjourned the hearing until 6 p.m. and directed government counsel to find out whether the government was in the process of removing people under the proclamation. ID at 13:15 it was. Although the government has refused to provide the particular details, all evidence suggests that during the short window that the court was adjourned, 2 removal flights took off from Harlingen, one around 5:25 p.m. and the other at about 5:45 p.m. See ECF number 21, RESP. To March 16th notice, at 3, for relying on flight tracking data for GlobalX flights 6143, 6145, and 6122. See also Marian Levine et al. White House official says 137 immigrants deported under Alien Enemies Act wash. Post March 16, 2025, https perma.ccu3 New York v3 as comparing flight tracking data with planes visible in 3-minute video posted online by President of El Salvador and reposted by President Trump 6 Case 1. 25 CV 00766 JEB document 81 filed 041625 page 7 of 46 and Secretary of State Rubio. Joyce Sohyun Lee and Kevin Shaw. Deportation flights landed after judge said plane should turn around. Wash. Post March 16, 2025. https perma.ccqd6j3seq. Same. Nayib Bukele at Nabukil. X March 16, 2025. 8:13 a.m. Eastern Daylight Time. https perma.ccxle4ddrw. Those later discovered flight movements, however, were obscured from the court when the hearing resumed shortly after 6:00 p.m. because the government surprisingly represented that it still had no flight details to share. See March 15th HRG TR at 15:18. See also ECF No. 51 March 21st HRG TR. At 7, defendant's counsel later affirming that at that time he had no information from the government as to the status of the flights. When pressed, government counsel stated that the operational details he had learned during the recess raised potential national security issues. So they could not be shared while the public and press listened to the hearing through a call-in line. See March 15th HRG TR at 15. He suggested, however, that the government could provide the court additional details in an in-camera setting. ID. So the court arranged to do just that. It disconnected the public line so that only counsel for the parties were present and asked government counsel to report. ID at 15:16, except that he did not. He clarified only that the additional details he had just mentioned could eventually be provided in camera, but he had no information to share at that time. ID at 16, with the growing realization, then, that the government might be rapidly dispatching removal flights in an apparent effort to evade judicial review, while also refusing to provide any helpful information. The court turned to the pending legal issues. ID at 18. After hearing argument, it first determined that venue was proper ID. At 18:22, and it next provisionally certified a class of plaintiffs covering all non-citizens in custody subject to removal solely under the proclamation. ID at 23:26, see also ID. At 38. 7 case 1:25 CV00766, JEB document 81 filed 041625 page 8 of 46. The court then addressed the sole remaining question, whether it should issue a broader TRO covering the entire class. It concluded that this was appropriate because plaintiffs had satisfied the factors governing emergency relief and because the distinct possibility, unrebutted by the government, that flights were actively departing or planning to depart required an immediate order preserving the status quo. ID at 41:43. The court therefore ordered that for 14 days the government was enjoined from conducting the removal of any non-citizens in its custody solely on the basis of the proclamation. ID at 42. Then, at about 6:45 p.m., the court delivered an oral command clarifying what compliance with the TRO meant. It directed government counsel to inform your clients of the order immediately, and to notify them that if class members were on a plane that is going to take off or is in the air, those people need to be returned to the United States. However that's accomplished, whether turning around a plane or not disembarking anyone on the plane, I leave to you. But this is something that you need to make sure is complied with immediately. ID. At 43. The hearing adjourned at 6:53 p.m. ID at 47. Roughly 30 minutes later, the court memorialized the TRO in a written order. See Minute Order of March 15th, 7:25 p.m. That order referenced the just concluded hearing and reiterated that the government was enjoined from removing class members. ID. Despite the court's written order and the oral command spelling out what was required for compliance, the government did not stop the ongoing removal process. According to defendants, the two planes that took off during the adjournment departed U.S. airspace before the court's 6:45 p.m. oral command. CECF no. 49-1, Robert L. Cerna III Decal. 5, and landed abroad sometime after the court posted the minute order at 7:25 p.m. CECF number 56, State Secrets Notice, at 7:08. A third flight reportedly took off from Harlingen at 7:36 p.m. See 8 Case 1. 25 CV00766, JEB Document 81 File 041625 page 9 of 46 Lee and Shaw, Supra, but the government maintains that all aboard were removed under authorities other than the proclamation. See Cerna Second Decal, 6. The first two planes, those carrying members of the plaintiff class covered by the TRO, apparently touched down in Honduras at 7:37 p.m. and 8:10 p.m. and remained there for several hours before taking off again for El Salvador. See Lee and Shaw, Supra, Levine et al., Supra. After the planes landed in El Salvador shortly after midnight on Sunday, see Lee and Shaw, Supra, most of the passengers were apparently transferred into one of that country's prisons, known as the Center for Terrorism Confinement, SECOT. But not all passengers, it seems. One Venezuelan woman swears in a declaration that she was on one of the flights that landed in El Salvador but was flown back to the United States along with 7 other women. Apparently because Salvadoran authorities on the ground refused to accept any female prisoners. See ECF number 55-1, SZFR Decal, 1-19-21. See also Didi Martinez, Julia Ainsley, and Laura Strickler. We were lied to. 2 women the Trump administration tried to send to El Salvador prison speak out. NBC News, April 2, 2024, https. Perma.ccf5y6, xcg8. Her account is corroborated by a declaration from a Nicaraguan man, who avows that he was also on board one of the removal flights, but was returned alongside the women, because Salvadoran officials would not take custody of Central American nationals, such as himself. See ECF number 55-2, Kadiana Gonzalez Decal, 179. By mid-Sunday morning, the picture of what had happened the previous night came into clearer focus. It appeared that the government had transferred members of the plaintiff class into El Salvador's custody hours after this court's injunction prohibited their deportation under the proclamation. Worse, both spy defendants intimated that they had defied the court's order deliberately and gleefully. The Secretary of State, for instance, retweeted a post in which, above 9 Case 1, 25 CV 00766, JB Document 81 Filed 041625 page 10 of 46, a news headline noting this court's order to return the flights to the United States, the president of El Salvador wrote, Oopsie, too late Bukele, at Nabiquil, X March 16, 2025, 7:46 a.m. Eastern Daylight Time, https. Perma.ccy384-4 TDW, https. Perma.cc6VTW5KRD, ellipses in original. B. Procedural background. A filing submitted by defendants on Sunday afternoon failed to dispel any concerns that they had flouted the court's injunction. CECF number 19, March 16th notice, see also RESP. To March 16th notice at 1:06, so the court set a hearing for Monday, March 17th, to determine what had transpired over the weekend. See minute order of March 17th, 3:09 p.m., denying ECF no. 24 Mo. To vacate March 17th HRG. The court expected that at the hearing, defendants might explain that, despite appearances otherwise, none of the people on the first 2 flights was a member of the plaintiff class. Or, at worst, defendants would admit to a grave mistake, explain how it transpired, and detail plans to rectify it. The United States government took neither tack. Rather, what followed in the ensuing days was increasing obstructionism on the part of the government as it refused to answer basic questions about what had happened. Questions that were all ultimately in service of resolving one key fact: whether members of the plaintiff class, that is, non-citizens removable solely on the basis of the proclamation, were transferred out of U.S. custody after this court's injunction preventing their deportation. Such stonewalling started before the Monday hearing. Just before it was set to begin, defendants sought to cancel it as an unnecessary incursion on executive branch authority. Moat. To vacate March 17th HRG at 1. Nowhere in their filing did they dispute that class members were transferred into Salvadoran custody hours after the injunction issued. Instead, defendants 10 Case 1. 25 CV 00766, JB document 81 filed 0416 25 page, 11 of 46, set forth several hyper-technical legal arguments for why, in spite of that fact, they had complied with the court's order. ID at 2, 5 such arguments were unconvincing then and remain so now. Then, in the hearing itself, the government refused to provide any relevant facts. The lawyer the government sent to the proceeding, conveniently not the counsel who had appeared at the TRO hearing, repeatedly stated in some form or another that he was not at liberty to disclose anything about any flights. ECF no. 25 March 17th HRG TR at 7. Although he would not say that such information was even classified, CID. At 9:10, he claimed that it could not be shared, even ex parte, with the court because of diplomatic concerns and national security concerns with flight patterns and things of that sort. ID. At 6:08 CID. At 30. That is, the government maintained that it could not share any details about the flights even privately with the court, despite the fact that, the previous day, defendants had retweeted a 3-minute video that portrayed a host of operational details. See Donald J. Trump at Real Donald Trump, Truth Social, March 16, 2025, 3:54 p.m. Eastern Daylight Time. https perma.ccwj8h f8hw. Secretary Marco Rubio at SE Rubio, X, March 16, 2025, 8:39 a.m. Eastern Daylight Time. https perma.cczd8jkgh. In high definition, the video displayed the planes and the runway where they parked, how migrants were restrained and transported, the faces and uniforms of many detainees, guards, and other officials, where the vehicles apparently entered Secot and the inside of the prison. ID. So, on Monday evening, the court ordered the government to submit another filing the next day. Seeking to accommodate defendants' national security concerns, vague as they were, yet nonetheless needing answers on how members of the plaintiff class had been transferred into a foreign prison. Hours after the injunction issued, the court directed the government to explain its position on whether, and in what form, it will provide answers to the court's questions regarding the particulars of the flights. Minute order of March 17th, 6:47 p.m. 11 Case 1:25, CV 00766, JEB document 81 filed 0416 25 page 12 of 46. The court again offered that such information could be provided in camera, including in a classified setting. ID. In their March 18th response, defendants reiterated their various arguments for why they should not have to share information related to flights, but conceded that if ordered to do so, they would submit an in-camera and ex parte declaration. ECF no. 28 March 18th notice. At 1:02, the court ordered defendants to do just that by noon the next day, and it set out 5 basic questions that the declaration needed to answer when the 2 flights in question took off and from where. When they left U.S. airspace, when they landed in a foreign country or countries. What time people subject solely to the proclamation and not other authorities, such as the Immigration and Nationality Act, were transferred out of U.S. custody. And how many people were on the flights solely on the basis of the proclamation. See Minute Order of March 18th, 2:27 p.m. Defendants then reversed course entirely. On Wednesday morning, the 19th, a few hours before their deadline, they moved this court to stay its Tuesday order on various grounds. See ECF number 37, Emergency Moat. To stay March 18th minute order. Most relevant, They asserted for the first time that they were considering invoking the state secret's privilege over the flight details and needed more time to make that determination. CID at 3. For the court was unsure how answering its 5 questions could jeopardize state secrets. Defendants, after all, had publicly shared images of the flights, making them trackable, and had still not claimed that the questions bore on any classified information. CECF no. 38 March 19th order, at 2, but nonetheless sought to accommodate their last-minute request. It gave them yet another day either to answer the 5 questions or to invoke the state secrets doctrine. ID at 4. 12 case 1:25 CV 00766, JB document 81 filed 04/16/25 page 13 of 46 on Thursday. The 20th, the government again evaded its obligations. ECF no. 47 March 20th order at 1. Rather than invoke the privilege or answer the questions, it submitted a short declaration from an immigration and customs enforcement officer stationed in Harlingen. CERNA 3rd Decal. It was his understand ing, he said, that cabinet secretaries were then considering whether to invoke the privilege. ID at 2. In response to this wholly inadequate response from a low-level official without any actual knowledge, the court required defendants to submit a declaration from someone directly involved with the cabinet-level discussions and gave defendants 5 days to indicate whether they were invoking the state secrets privilege. See March 20th order at 3. The government has since invoked it. See state secrets notice. The court also directed the parties to brief whether defendants had violated the court's TROs. See March 20th order at 3. That briefing is complete, and the court held a hearing on the matter in early April. In parallel to the investigation of defendants' compliance have been further proceedings on the trust merits. After briefing and a hearing, the court denied defendants' motion to vacate the TROs. It held that plaintiffs had shown a likelihood of success on one of their core claims, i.e., those subject to removal under the proclamation had a due process right to challenge the government's determination that they were removable and that they would face irreparable harm if the TROs were dissolved, a harm that also tipped the balance of equities in their favor. See JGG 2025 WL 890401 at 11, 14, 16, 17. The Court of Appeals then rejected defendants' request to stay the orders, raising concerns with both the applicability of the Act and the lack of due process. CJGGV, Trump, number 25 to 5067, 2025 WL 914682, at 8:10 DCCIR. March 26, 2025, Henderson, J., concurring, ID. At 13:14 Millet, J., concurring. 13 case 1:25, CV 00766, JB document 81 file 04/16/25 page 14 of 46. The Supreme Court subsequently vacated the TROs on a narrow ground. It held that challenges to removal under the Act must be brought through a habeas corpus proceeding, not, as plaintiffs did, through the Administrative Procedure Act, and therefore venue lay in the District of the class member's confinement, not the District of Columbia. CJGG 2025 WL 102 for 097 at 1. While the court split on the venue question, it unanimously held, as this court did when declining to dissolve the TROs, that those subject to removal under the Act must be allowed to challenge their removability in federal court before being deported. CID at 2 ID. At 2 Kavanaugh, J., concurring, ID. At 2 6 Sotomayor, J., dissenting. Specifically, all justices agreed that the Due Process Clause requires the government to provide anyone it seeks to remove notice that they are subject to removal under the Act, and to do so within a reasonable time and in such manner as will allow them to actually seek habeas relief before being removed. ID at 2 per curiam, ID. At 6 Sotomayor, J., dissenting. In holding as much, the court effectively said that the Constitution flatly prohibits the government from doing exactly what it did that Saturday, when it secretly loaded people onto planes, kept many of them in the dark about their destination, and raced to spirit them away before they could invoke their due process rights. As this opinion will shortly explain at greater length, the fact that the Supreme Court determined that this court's TRO suffered from a venue defect does not affect, let alone moot, the compliance inquiry presently teed up here. 2. Analysis defendants provide no convincing reason to avoid the conclusion that appears obvious from the above factual recitation, that they deliberately flouted this court's written order and, separately, its oral command that explicitly delineated what compliance entailed. They do not 14 case 1:25 CB 00766 JB document 81 filed 0416 25 page 15 of 46 dispute that it was hours after the written order issued when they disembarked the class members aboard the two planes and transferred them out of U.S. custody. See State Secrets Notice at 7, 8 ECF No. 58 RESP at 4. Rather than offer a mea culpa and attempt to explain this grave error and detail plans to rectify it, defendants offer various imaginative arguments for why they nevertheless technically complied with the order. None of their positions withstand scrutiny. Defendants' core contention that in prohibiting class members' removal, the written order barred only their physical exit from the United States, not their subsequent transfer into Salvadoran custody, requires ignoring the clear context in which the order was issued. Their other arguments amount only to retroactive attacks on the legal validity of the injunction, but that road leads nowhere. Even a legally defective order must be complied with until reversed through the appeals process. Defendants' conduct, moreover, manifests a willful disregard of the court's legally binding prescriptions. Given the evidence at this early stage in the inquiry, and offered no persuasive reason to conclude otherwise, the court finds that there is probable cause that defendants acted contemptuously. The following analysis first sets out the parameters of criminal contempt, and then explains why court orders, regardless of their ultimate validity, must be complied with. The court last analyzes why defendants' willful and knowing actions here constitute probable cause for a finding of contempt. A. Contempt 1. Legal standard. When Congress established lower federal courts in the Judiciary Act of 1789, it conferred on them the power to punish by fine or imprisonment at the discretion of said courts. All 15 case 1:25 CV 00766 JEB document 81 filed 0416 25 page 16 of 46 contempt of authority in any cause or hearing before the same. 1 stat. 83 C. Bloom versus Illinois, 391 U.S. 194, 202, 1968. In doing so, Congress gave federal courts the discretionary power to punish for contempt, as that power was known to the common law. United States versus Barnett, 376 U.S. 681, 687, 1964, CID. At 699, 700, the power to fine and imprison for contempt, from the earliest history of jurisprudence, has been regarded as a necessary incident and attribute of a court, without which it could no more exist than without a judge. Quotation marks omitted. United States versus Dixon, 509 U.S. 688, 694, 95, 1993. Although Congress eventually pared back federal courts' statutory contempt power, it preserved their authority to punish, among other transgressions, disobedience or resistance to court orders. Dixon, 509 U.S. at 694, quoting 4. Stat 488. C. Bloom, 391 U.S. at 202, 04. That statutory authority is now codified in 18 U.S.C. 401, which provides that any court of the United States shall have power to punish by fine or imprisonment, or both, at its discretion. Disobedience or resistance to its lawful writ, process, order, rule, decree, or command, for a contemner to be convicted of criminal contempt under 401(3). It must be shown beyond a reasonable doubt. 1. That the court order was clear and reasonably specific. 2. That the defendant violated the order. And 3. That the violation was willful. United States versus Young, 107 F.3 D 903, 907 DCCIR. 1997, quoting United States v. 9X Corp., 8F.3D52, 54 DCCIR. 1993. The court here inquires only into whether there is probable cause that defendants violated 401. Such an inquiry does not appear to be strictly necessary. The statute does not include a probable cause requirement, and as the Department of Justice has explained in an internal manual, it is unclear whether probable cause that a willful violation has occurred is a condition precedent to the commencement of a criminal contempt action. U.S. Dept of Just, 16 Case 1. 25 CV 00766, JB Document 81 File 0416 25 page 17 of 46 Criminal Resource Manual 763. HTTPS, in practice, the vast majority of criminal contempt decisions make no mention of such a requirement. ID. Some courts, however, have opted to make or require findings of probable cause before initiating criminal contempt proceedings. CEG in Residential Tech, Corp. 2008 WL541 1771 at 4 NDL. December 23, 2008, Beyond Blonde Prods, LLCV, Heldman, 2025 WL902445 at 1 CD Cal March 25, 2025, in Resitter 132 BR 243, 245, 46, EDNY Banker. 1991, Reed v. Rhodes, 500 F's Up, 363, 376, 404, ND Ohio 1980. United States v. Hovind, 2014 WL128876669, at 2, ND Flaw July 8, 2014. In Reunited Corp., 166 F's Up. 343, 345 D. Del 1958. The court finds that practice to be a prudent way of affording alleged contemners the procedural protections associated with other criminal proceedings, and so follows it here. 2. Effect of Supreme Court vacator, but hold on, defendant's protest. If the Supreme Court has since vacated the TROs, how can contempt lie? CECF number 78. Notice regarding Supreme Court decision, at 1. The Supreme Court long ago answered that question. It is firmly settled that a court order must be obeyed until it is reversed for error by the issuing court or a higher one. Walker, 388 U.S. at 314, quoting Howard v. Kansas, 258 U.S. 181, 189, 90, 1922. That, in turn, means that a party may be punished for criminal contempt for disobedience of an order later set aside on appeal for being defective. United States v. United Mine Workers of AM, 330 U.S. 258, 29495, 1947. If a party believes that a court order suffers from legal deficiencies, it therefore must have the injunction modified or vacated. It cannot simply ignore it. Evans v. Williams, 206 F.3D 1292, 1299, DCCIR. 2000. The so-called collateral bar rule enforces that principle. It provides that if a party is charged with contempt for disobeying a court order, it cannot raise the legal invalidity of the order as a defense. CID, citing Walker, 388 U.S. 307. Defendant 17 Case 1:25, CV, 00766. JB Document 81 File 0416 25 page 18 of 46 were thus obligated to comply with this court's TRO until vacated by this court or a higher one. If they failed to comply, the fact that the TRO was legally unsound is no obstacle to a contempt conviction. There are only two narrow exceptions to this rule, neither of which applies here. First, an enjoined party can violate an order and then challenge its validity in a contempt proceeding if, and only if, there was no opportunity for effective review of the order before it was violated. 11 A. Charles A. Wright and Arthur R. Miller, Federal Practice and Procedure 2960, 3D ed. April 2025 update. Defendants do not seek cover behind this exception. For good reason. Just as they had sought emergency appellate relief for the first TRO mere hours after it issued. CECF no. 12. First notice of appeal. They notified this court while the planes were en route to El Salvador that they intended to do the same for the TRO in question. CECF no. 17. Second notice of appeal. Filed 8:37 p.m., docketing their appeal only minutes after the planes landed in that country. See corrected emergency mode. For a stay pending appeal, JGGV, Trump, no. 25 to 5067, DCCIR March 16th, 2025, filed 1:07 a.m. Sunday. Defendants also could have sought relief from this court, including, for example, requesting a stay of the TRO pending appeal. See Federal R App P8A 1A JGG 2025 WL914682 at 22, 23 Millet J, concurring, noting failure to do so. Defendants, moreover, nowhere identify a reason that the transfer had to occur early Sunday morning. If they considered waiting for appellate relief impracticable or unattractive given the speed at which events transpired, that circumstance was entirely of their own making, not the result of any bona fide obstacle to effective review. Indeed, the appellate process worked at a breakneck pace. C.F. Walker, 388 U.S. at 318. 19 cases different if party faces delay or frustration of their claims in appellate courts. 18 case 1:25 CV 00766, JB document 81 filed 041625 page 19 of 46 second. A party need not obey an injunction that is transparently invalid or had only a frivolous pretense to validity. ID. At 315. That is an exceedingly high bar. This narrow carve-out does not apply if the order was arguably proper or had any pretense to validity at the time it was issued. Matter of Providence J. Co. 820 F.2 D 1342, 1347, First Circle. 1986. The exception therefore applies, O and LY in the rarest of situations. Zapon v. U.S. Depth of Just, 53 F.3 D 283, 285, Ninth Circle. 1995. This is not one. The Supreme Court has admittedly held that plaintiff's claim should have been brought in habeas. CJGG 2025 WL102 for 097 at 1. But this court's view of the issue at the time of the orders was not patently frivolous. Rather, the question was substantial. United Mine Workers 330 U.S. at 293, dividing both the Court of Appeals and the Supreme Court. CJGG 2025 WL914682 at 23, 31 Millet J, concurring ID. At 34, 37 Walker J, dissenting, JGG 2025 WL102 for 097 at 1 ID. At 7, 10 Sotomayor J, dissenting. To be sure, some courts outside this circuit have suggested that when a court lacks subject matter jurisdiction to adjudicate a dispute, an enjoined party may raise that fact as a defense to contempt. CEG in Reno Vac 932 F.2 D 1397, 1401, 02, 11th Circle. 1991 in Rhea Stab. Inspection of Hearn Iron Works, Inc. 881 F.2 D 722, 726, 27, 726 and .12, 9th Circle. 1989, but noting pervasive uncertainty on the issue. Those statements, however, do not control here, not least because they are incompatible with the Supreme Court's subsequent opinion in Willie v. Coastal Corp. 503 U.S. 131, 1992. See United States v. Straub, 508 F.3 D 1003, 1006, 1010, 11th Circle. 2007, upholding 18 U.S.C. for 013, contempt charge even though court lacked jurisdiction over the underlying controversy, and noting Willie resolved this issue. In Willie, a district court imposed Rule 11 sanctions, which function like criminal contempt, as they are designed to punish a party who has already violated the court's rules. 50319 Case 1. 25 CV 00766, JEB document 81 filed 0416 25 page 20 of 46 US at 139, even though it was later shown that it did not have subject matter jurisdiction when the sanctionable conduct occurred. Indeed, it issued the final sanctions order after its lack of jurisdiction had been determined by the Court of Appeals. ID at 133, 34, the Supreme Court nonetheless upheld the sanctions order. ID at 135, 39, a final determination of lack of subject matter jurisdiction, the court explained, precludes further adjudication of the case's merits, but a sanctions order is collateral to the merits. So, a court's lack of subject matter jurisdiction poses no constitutional bar. ID at 137, 38. See also ID. At 137, explaining that United Mine Workers, 330 U.S. 258, upheld a criminal contempt citation even on the assumption that the district court issuing the citation was without jurisdiction over the underlying action. Following Willie, the D.C. Circuit has made clear that subject matter jurisdiction over an underlying action is not a precondition of a federal court's authority to sanction those who violate its orders. In Re. Lufonda, 919 F.3D 554, 561, DCCIR. 2019, citing Willie, 503 U.S. at 137. Notwithstanding whether a court is later determined to have lacked subject matter jurisdiction at the time of the violation, then a party can be held in contempt for disobedience. And the same court can impose the sanctions even after its lack of jurisdiction has been revealed. In any event, this court possessed such jurisdiction. Recall, the Supreme Court held in its per curiam opinion that claims challenging removal under the Alien Enemies Act must be brought in habeas. JGG 2025 WL102 for 097 at 1. That conclusion rested on a line of cases holding that habeas is the exclusive remedy for state prisoners challenging their sentences, even though such claims may come within the literal terms of another statute. Heck versus Humphrey, 512 U.S. 477, 481, 1994. See also Pricer versus Rodriguez, 411 U.S. 475, 489, 90, 1973. In such circumstances, the court has previously explained, the availability of habeas relief means a separate cause of action does not accrue. Heck, 512 U.S. at 489, 90. By 20 case 1:25, CV 00766, JB document 81 filed 0416 25 page 21 of 46 analogy, the same occurred here. In holding that habeas is the exclusive remedy for plaintiffs, the Supreme Court denied that they possessed a valid cause of action under the APA when this court granted the class-wide TRO. It did not hold that this court lacked subject matter jurisdiction. In fact, Justice Kavanaugh noted in his concurrence that the availability of habeas relief constitutes an adequate remedy, barring suit under the APA. CJGG 2025 WL102 for 097 at 2 Kavanaugh J. Concurring, quoting 5 USC 704. See also JGG 2025 WL914682 at 34 Walker J. Dissenting, making same point. The adequate remedy bar, however, is not a jurisdictional one. On the contrary, the D.C. Circuit has explained that 704 determine whether there is a cause of action under the APA, not whether there is federal subject matter jurisdiction. Perry Capital LLCV, Mnuchin, 864 F.3D 591, 621 DCCIR. 2017. Under either habeas or APA precedents, then, both paths lead to the same destination. The relevant defect in this court's class-wide TRO was not jurisdictional. At worst, as the Supreme Court held here, venue was improper in the District of Columbia. JGG 2025 WL102 for 097 at 1, emphasis added. Indeed, regardless of how the issue is framed, the court has been clear that any reference to habeas jurisdiction does not refer to a court's subject matter jurisdiction. Rumsfeld versus Padilla. 542 US 426, 434 numero 7, 2004. Rather, the territorial jurisdiction rule is a question of proper venue. ID. At 452, Kennedy, J., concurring, see also Chapman Bay v. Thornburg, 864 F.2D 804, 812, 13, DCCIR. 1988, similar. And it is black-letter law that while subject matter jurisdiction goes to whether any federal court may even hear the dispute, venue determines which jurisdiction-possessing court is the most convenient. C14D Wright and Miller, Supra, 3801, 4th ed. April 2025 update. Nerbo Co. versus Bethlehem Shipbuilding Corp., 308 U.S. 165, 167, 68, 1939, same. Just 21 case 1:25, CV 00766, JEB document 81 filed 04/16/25 page 22 of 46, like the availability of a cause of action under the APA. That question has been determined by statute, the federal habeas statute. See 28 U.S.C. 2241, 2242. The upshot is that, after the Supreme Court's decision in this case, it has been preliminarily determined that Congress channeled a challenge to removal under the Alien Enemies Act to a habeas petition filed in a detainee's district of confinement. This court's decision to recognize a cause of action under the APA in the District of Columbia, while ultimately found erroneous by the Supreme Court, therefore is not a defect that would excuse compliance under any of the recognized exceptions. The firmly established rule of law that even a legally unsound order must be obeyed at the risk of contempt, therefore, focuses the present inquiry. Walker, 388 U.S. at 319. The question presented here is whether there is probable cause that defendants deliberately or recklessly disregarded a clear and reasonably specific order. C. Young, 107 F.3d at 907, 910. The question is not, as many of defendants' evasive legal arguments imply, whether that order was legally impeccable. 3. Sufficiently clear, reasonably specific, and unequivocal order. The first element of contempt requires that the injunction be clear, reasonably specific. Young. 107 F.3d at 907, quotation marks omitted, and unequivocal at the time it is issued. In Re Holloway, 995 F.2d 1080, 1082, DCCIR. 1993, quoting Traub versus United States, 232 F.2d 43, 47, DCCIR. 1955, to determine whether an order is sufficiently clear and specific, courts apply an objective standard that takes into account not just the language of the order, but also the objective circumstances surrounding the issuance of the order. Young. 107 F.3d at 907. Thus, W. Whether an order is clear enough depends on the context in which it was issued, which includes the audience to which it was addressed, ID. At 907-08, quoting 22 case 1:25, CV 00766, JEB document 81 filed 04/16/25 page 23 of 46 in Re Levine, 27 F.3d 594, 596, DCCIR. 1994. As well as the relief sought by the moving party, the evidence produced at the hearing on the injunction, and the mischief that the injunction seeks to prevent. Common Cause versus Nuclear Regal. Common 674 F.2d 921, 927, DCCIR. 1982, quotation marks omitted. The question here, then, is whether it was sufficiently clear to the government that the court was prohibiting it from transferring class members into another country's custody, something defendants admit to doing ours. After the written order issued, see State Secrets Notice at 7-8. The government, however, now contends that the court's order should be understood to have enjoined it only from transporting class members outside of U.S. territory, not from relinquishing custody of them once they were already outside the United States. That narrower order, it argues, was one with which it fully complied. that interpretation is deliberately blind to the court's unequivocal language and the context surrounding its order. At 7:25 p.m. on Saturday evening, roughly 30 minutes after the hearing adjourned, see March 15th HRG. TR. At 47, the court issued its written order. See Minute Order of March 15th, 7:25 p.m. Expressly referencing the hearing, the order certified a plaintiff class consisting of all non-citizens in U.S. custody who were subject to the proclamation, and, relevant here, memorialized the TRO using the same language as in the hearing. See March 15th HRG, TR, at 42, 46, 47. Specifically, this part of the order stated, as discussed in today's hearing, the court orders that T government is enjoined from removing members of the class, not otherwise subject to removal, pursuant to the proclamation for 14 days, or until further order of the court. Minute Order of March 15th, 7:25 p.m. As already explained, the government does not dispute that after this written TRO issued, it temporarily landed 2 plane loads of class members in Honduras, flew them to L-23 Case 1. 25 CV 00766, JB Document 81 Filed 04-1625 page 24 of 46 Salvador, deplaned them there, and then, critically, transferred them from U.S. to Salvadoran custody. See State Secrets Notice at 7:8. Indeed, the government does not challenge that this transfer of custody happened some 5 hours, at least, after the written order was docketed. See Levine et al., Supra. Planes landed in El Salvador at 12:10 and 12:18 a.m. Defendants offer a novel interpretation of the order that, if adopted, would mean that they were not in violation. The linchpin of their argument is that in forbidding them from removing class members, see Minute Order of March 15th, 7:25 p.m., the TRO prohibited only flying class members outside of the United States, not the further act of relinquishing custody of them into the hands of a foreign government. See RESP at 2. And they continue because both planes had already departed U.S. airspace before the written order posted and before the oral command preceding it. Everyone on board had already been removed before the order issued. CID. While perhaps clever, this argument does not carry the day. Defendants agree that an injunction must be understood in the context in which it is issued. See Young 107 F.3d at 907-08, RESP. At 2. But they would have the court search for context in all the wrong places. After observing that the written TRO did not define remove, RESP. At 3. They seek to show that the term has a clear meaning under the Act, with the implication that the court incorporated that definition into its order. They do not make their case. Across a couple paragraphs, defendants half-heartedly seek to root their narrow reading of removal in the Act. They cite several dictionary definitions from around the time that Congress passed the Alien Enemies Act in 1798, but these are far from conclusive. See RESP at 3. They also suggest that their territorial understanding makes sense because the Act speaks of the territory of the United States. ID. Quoting 50 U.S.C. 21. This, too, is hardly definitive. 24 Case 1. 25 CV 00766, JEB Document 81 Filed 04-1625 page 25 of 46, just because an invasion or predatory incursion must be against the territory of the United States to trigger the acts. Authorities does not resolve whether the process of removal comprises a physical departure or a transfer of custody. Defendants therefore fall well short of showing that removal carries a definitive meaning under the Act. As a fallback of sorts, defendants gesture toward the adjacent INA context, but that undercuts their position. CID. At 320, the rule reflects a belief that in the fair administration of justice no man can be judge in his own case, no matter how exalted his station or righteous his motives. ID. At 320, 21 the Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to Nick Usurimis v. Sessions 902 F.3d 895, 898, 899, Ninth Circle. 2018 citation omitted. That court, however, recognized that departure can convey a physical departure, territorial exit, or, conversely, a legal departure, implicating questions of one's legal admission to and status in the country of destination, and it found that the former controlled only because the INA's own statutory definition made that conclusion unavoidable. ID at 899, 900, noting statute defined deported or removed as having left the United States, quotation marks omitted. Here, by contrast, as defendants concede, see RESP. At 3, we have no statutory definition that might be dispositive. Insofar as INA cases are relevant, moreover, they demonstrate that at the time the TRO issued, the government understood removal to mean the exact opposite of what they now claim. But don't take the court's word for it. Just listen to the argument the government made a mere 5 days before the events in question here. In a different case in this district, with some of the same defendants, and in a filing signed by some of the same lawyers signing defendants' show cause response, the government argued that removal under the INA is a term of art, and that to effectuate a departure or removal, the alien must lawfully enter another country. As the fact that he is physically on foreign soil is not alone sufficient to establish that he has 25 Case 1. 25 CV 00766, JEB document 81 filed 041625 page 26 of 46 legally departed the United States. Escalona versus No. 25 to 604, ECF number 14, op to mote. For stay of transfer at 2930 DDC March 10th, 2025, citations omitted, CID. At 40 lawyers. Defendants, then, do not show that removal carries the specific meaning they urge under the Act. For that reason, rather than a smattering of late 18th century dictionaries and an inconclusive fragment of the Act's text, the better, indeed the obvious, place to look for the meaning of removal in the court's written TRO is the hour-plus long hearing that immediately preceded it. See Young 107 F.3d at 907, 08. Context for determining meaning of injunction includes objective circumstances surrounding the issuance of the order and audience to which it is addressed, quotation marks. Omitted. Anyone paying attention to the hearing, as the government presumably was, would have known that the ultimate action plaintiff sought to prevent through a TRO was not their mere transportation across the U.S. border, but instead their discharge from U.S. custody into a foreign country or into foreign hands. Common Cause 674 F.2d at 927. Context for determining meaning of injunction includes the relief sought by the moving party and mischief that the injunction seeks to prevent. When the court accordingly referred to removal or deportation in the hearing, it consistently used those terms to mean a legal departure that was complete upon discharge from U.S. custody, not upon mere physical exit from U.S. territory. First, mark the opening exchange of the hearing. The court asked the government to confirm that none of the 5 named plaintiffs was on any plane that has departed, March 15th HRG. TR. At 4, as the first TRO then in place prohibited their remove out from the United States. Minute order of March 15th, 9:40 a.m. Government counsel said that he had confirmed that they would not be removed. See March 15th HRG. TR at 5. The court then clarified what that must entail, stating, I would assume that means that they are either not on the planes or that they 26 Case 1. 25 CV 00766, JEB document 81 filed 041625 page 27 of 46 will not be removed from the planes and will be brought back once the planes land in El Salvador. ID. Emphasis added. The government did not disagree with that characterization. ID. From the start, then, the court plainly considered removal from the United States, i.e., the action that would violate the TRO, to mean a legal removal, and specifically a process that culminated not in a detainee's movement out of U.S. airspace or arrival in a foreign country, but instead upon his transfer out of U.S. custody. Similarly, during a later exchange on irreparable harm, The court expressly said that it viewed the status quo, which plaintiffs sought to maintain, as keeping class members in IC custody but not deporting them. March. 15 ARG TR at 35. Again, the issue was custody, not physical location. Second, consider the recurring discussion about when and how the court would lose equitable jurisdiction. These exchanges make clear that the court considered a TRO to be appropriate in part to preserve the status quo. That the court and plaintiffs felt that this entailed ensuring that it did not lose jurisdiction, and that it was concerned that it would lose jurisdiction not when class members exited U.S. airspace, but instead when they left U.S. custody. The government listened to and indeed participated in these exchanges. To start, prior to the mid-hearing adjournment, plaintiffs' counsel interjected that sources on the ground had indicated that planes were actively departing or could be at any moment. ID at 12. That created time pressure, he said, but not because class members would simply be flown outside the United States. Instead, it was because they could imminently end up in a Salvadoran prison, and that eventuality might divest this court of jurisdiction. ID. The reason was explained later in the hearing, when the discussion returned to irreparable harm. The government said that it did not understand plaintiffs' irreparable harm argument, which it construed to be predicated on the premise that this court would somehow lose 27 Case 1. 25 CV 00766, JB Document 81 Filed 041625 page 28 of 46 jurisdiction, if class members were in the United States but not in D.C. ID. At 35. The court clarified for the government that plaintiffs' argument in part is that class members are going to be sent to Salvadoran or Honduran prisons. ID. Emphasis added. Indeed, that event, plaintiffs again agreed, was the crux. Not only did they face real danger, if they end up in a Salvadoran prison, but if that were to occur, the court would lose jurisdiction because it wouldn't be able to offer a remedy, and a TRO was needed to prevent both things from happening. ID at 36. 37. The government surely understood the black letter principle that to have jurisdiction, a court must be able to redress the plaintiff's injury. See Ajuegbanum versus Prexuski, 592 U.S. 279, 291, 2021. Plaintiffs here clearly recognized that if they were turned over to Salvadoran authorities, the court might lose its ability to offer any remedy. While a federal court can exercise equitable powers over U.S. officials, even if they are overseas, it cannot directly control foreign officials. Cito versus Mattis, 928 F.3 D1, 22 DCCIR. 2019, meaning that this court could not order the guards at Secot to release class members. But see Abu Ali versus Ashcroft, 350 F Sup. 2D28, 30, 31, 47, 50 DDC 2004, denying motion to dismiss habeas petition filed by U.S. citizen held in Saudi prison at United States' behest because prisoner was in constructive U.S. custody. Munif versus Jaron, 553 U.S. 674, 686, 2008. One is held in custody by the United States when a U.S. official has the power to produce him, citation omitted. In an egregious case of cherry picking, defendants selectively quote only a fragment of the court's response here to mischaracterize its position, suggesting that the court acknowledged that it lacked jurisdiction once class members left U.S. airspace. See RESP at 8, see also ID at 11. But that contention overlooks that the first words of the response, right? Sure. I mean, once they are out of the country, I'm not sure what I can do there. March 15th, HRG. TR at 36, 28 Case 1:25, CV 00766, JB Document 81 Filed 041625 page 29 of 46, affirm plaintiff's custody-based articulation of why it would lose jurisdiction. Defendant's suggestion also ignores the court's prior and repeated references to removal as a transfer of custody. Any lingering doubt on this score is dispelled by the exchange that occurred just a few minutes later. Immediately after the court ruled on the TRO and delivered the oral command on how it should be implemented, which will be addressed shortly, CID. At 42:43, plaintiffs provided an update on the 2 flights that they understood to have taken off that afternoon. One had ended up in El Salvador and the other in Honduras, they said. ID at 44. In response, the court said, again, just so we are clear, if planes have already landed and discharged their occupants, aside from the 5 plaintiffs I enjoined earlier, then I don't have jurisdiction to require the occupants' return. ID, emphasis added. Right, agreed plaintiffs. ID. If the court believed jurisdiction to be territorial, it would not have said the emphasized portion. Instead, its answer would have been, if the planes have left the United States, I don't have jurisdiction to require their return. In short, then, these exchanges on equitable jurisdiction, in which the government was both audience and participant, Young, 107 F.3d at 907.08, demonstrate that plaintiffs sought a class-wide TRO that would ensure that the court retained that jurisdiction over class members, that the court agreed that it would lose such jurisdiction upon class members' handover to foreign authorities and not before, and that the only TRO the court was considering granting was one that would prevent such an eventuality. Third, return to the oral ruling in command. At around 6:45 p.m., the court ruled on plaintiffs' request for a broader TRO covering all class members. After explaining the reasons that a TRO covering the plaintiff class was appropriate, the court spelled out its scope. The TRO would be to prevent the removal of the class for 14 days, or until further order of the court. 29 Case 1:25, CV 00766, JEB Document 81 Filed 04/16/25, page 30 of 46, and the class will be all non-citizens in U.S. custody who are subject to the proclamation and to its implementation. March 15 HRG TR at 42, emphasis added. After noting that it would memorialize the TRO through a minute order, the court then addressed where we go from here, ID, and turned to the government to emphasize the first point. Why? You shall inform your clients of the order immediately, and that any plane containing class members that is going to take off or is in the air needs to be returned to the United States. But those people need to be returned to the United States. However that's accomplished, whether turning around a plane or not disembarking anyone on the plane, I leave to you, but this is something that you need to make sure is complied with immediately. ID at 43, emphasis added. From this command alone, it was clear and unequivocal that the ultimate action prescribed by the TRO was not class members' removal from U.S. territory, but instead their transfer from U.S. custody into foreign hands. If the court's TRO only prohibited class members from being transported out of U.S. territory, much of the oral command would be nonsensical. It would make no sense to command that people who had never left the United States needed to be returned to the United States. ID. Emphasis added. Nor would it make any sense for the court to have ordered the government not to deplane anyone on a plane. ID. The inescapable meaning of that directive, particularly in light of the exchanges leading up to it, was that anyone on a removal flight that had already landed abroad should not be discharged from U.S. custody and turned over to Salvadoran or Honduran authorities. That was clearly the ultimate harm plaintiffs sought to prevent and the jurisdiction-terminating event they endeavored to preclude by freezing the status quo. If the injunction only prevented class members' exit from U.S. airspace, the court would have had no need to detail how they should be handled if their plane had already landed abroad. 30 Case 1:25, CV 00766, JB Document 81 Filed 04/16/25, page 31 of 46, in sum, numerous exchanges throughout the hearing, including the ultimate unequivocal oral command that clarified how the TRO must be obeyed, demonstrate that the court consistently considered removal to be not mere physical removal, but instead legal deportation that was complete upon transfer out of U.S. custody. Defendants' proposition that the written order used removal in a dramatically narrower sense flies in the face of this overwhelming context, and they provide no convincing explanation for why, after its emphatic oral command, the court would have made an abrupt U-turn in the 30-minute window between the end of the hearing and the docketing of the order. Contra RESP at 7. Indeed, the court twice told the government in the hearing that it would memorialize the TRO in the written order. See March 15th HRG. TR at 42, 46, the only objectively reasonable expectation, then was that the written order enshrined the injunction unchanged unless the court expressly drew attention to any discrepancies between what was said and what was recorded in writing. Nor did the government seek to clarify the relationship between the oral command and written order, which it plainly should have done had it felt any confusion. The court therefore concludes that the written TRO and the oral command defining compliance were each sufficiently clear and specific in prescribing the handover of class members to Salvadoran officials. For violation, the second element of contempt requires that the sufficiently clear and specific order was in fact violated. Young, 107 F.3d at 907. Defendants do not dispute that if the order indeed prescribed transferring class members out of U.S. custody, they plainly violated it hours after it issued. Rather than mount any factual defense, they rely on post hoc legal arguments to attack the validity of the order itself. These positions are without merit, but more important, they are 31 case 1:25 CV 00766, JB document 81 filed 0416 25 page 32 of 46, not even available to defendants. As previously explained per the collateral bar rule, what matters is whether they violated the terms of the order, not whether the order itself was legally valid. A. Separation of powers. Defendants first claim that even if the TRO used the term removal to describe a legal departure, and thereby did enjoin, as previously explained per the collateral bar rule, what matters is whether they violated the terms of the order, not whether the order itself was legally valid. A. Separation of powers. Defendants first claim that even if the TRO used the term removal to describe a legal departure, and thereby did enjoin class members transfer into foreign custody, it did not prohibit, indeed could not prohibit, defendants from making such a transfer if the class members were already outside the United States at the time of the order. See RESP at 9 ID, at 2-913. That argument sails wide of the mark. Underpinning their claim is a sweeping assertion. They contend that once the class members exited U.S. airspace, defendants' authority over them flowed solely from the President's Article 2 powers, not from the congressional grant of immigration authority invoked by the proclamation. ID at 10-12. In their view, from El Valle to the U.S. border, defendants transported class members pursuant to the Act. Upon exiting U.S. airspace, however, the Act fell away, and defendants continued on under only the President's Article 2 powers. From that bold premise, defendants urge 2 points. They first posit that because it only enjoined removals effectuated pursuant to the proclamation, minute order of March 15th, 7:25 p.m., the TRO by its terms did not reach conduct outside of United States territory taken pursuant to Article 2. See RESP at 9-10-12. Even were the premise solid, which it is not, this is simply another argument about how the TRO should be construed based on its language. But we have already been down this path. The TRO should be understood in light of the circumstances in which it issued, not given a belated gloss by virtue of sweeping separation of powers theories raised for the first time in briefing. To reiterate again, the relevant context here demonstrates that the order clearly and specifically prohibited defendants from transferring 32 Case 1. 25 CV 00766, JB document 81 filed 0416 25 page 33 of 46, any class members into a Salvadoran prison, even, in fact, especially if they had already been flown outside the United States. See Super PP 26. 30. To the degree that defendants' objection does not concern the order's interpretation, it melds into their secondary argument. Even if the court's order prohibited or purported to prohibit CRESP. At 9, transferring custody of class members already outside the United States, the court lacked the constitutional power to enjoin such transfers. ID at 11, executive branch's handling of class members abroad, was beyond the court's authority to adjudicate. This position does not persuade. First and most important, the collateral bar rule stops it in its tracks. Even if defendants' theory of Article 2 power were sound, it would not help them in this contempt inquiry. The argument, at bottom, is an attack on the legal validity of the TRO. By restraining their conduct, defendants say The order infringed on the president's Article 2 powers and thus violated the Constitution. See RESP at 7 ID. At 12, extraterritorial exercise of President's Article 2 authority presents a non-reviewable political question. But as explained above, defendants cannot defend contempt charges by asserting the unconstitutionality of the injunction. Carroll versus President and Comaris of Princess, and 393 U.S. 175. 179, 1968, citing Walker, 388 U.S. 307. If defendants believed, correctly or not, that the order encroached upon the president's Article 2 powers, they had two options. They could seek judicial review of the injunction, but not disobey it. Or they could disobey it, but forfeit any right to raise their legal argument as a defense against criminal contempt charges. See Super PP 17. 18, they chose the latter course. Even if their Article 2 argument could be construed as something other than a barred collateral attack on the legal soundness of the orders, it would still come up short. There is number 33 case 1:25, CV 00766, JB document 81 filed 0416 25 page 34 of 46 merit to their contention that outside U.S. airspace, defendants somehow operated solely under the president's commander-in-chief powers, not the Alien Enemies Act. The Constitution gives Congress plenary authority over immigration, INSV, Chutta, 462 U.S. 919, 940, 1983. So any discretion over the admission and exclusion of aliens possessed by the executive extends only as far as the statutory authority conferred by Congress and may not transgress constitutional. Limitations. Aborzek versus Reagan, 785 F.2D 1043, 1061 DCCIR. 1986. Since the Act's passage, moreover, an unbroken line of cases has considered the disposition of alien enemies during a state of war to be within Congress's constitutional ambit, not the president's. See Ludek, 335 U.S. at 173, ID. At 161, Brown versus United States, 12 U.S., 8 Cranch, 110, 126, 1814, Marshall. CJ. Act affords a strong implication that President did not possess power over alien enemies by virtue of a declaration of war. Citizens Protective League versus Clark, 155 F.2D 290, 293, DCCIR. 1946. Although defendants offer certain soundbite-ready assertions, see State Secrets Notice at 1, declaring President's plenary authority, derived from Article 2 and the mandate of the electorate, to remove from the homeland designated terrorists. They cite no legal authority that defendants here operated pursuant to a presidential power preclusive of both congressional and judicial power. Such an extraordinary claim must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. Youngstown Sheep and Tuco versus Sawyer, 343 U.S. 579. 638, 1952. Jackson, J. concurring. Yet across multiple filings, they muster not a single case in direct support of the proposition that when the government carries out deportations pursuant to a grant of statutory authority, that authority is necessarily eclipsed by the executive's exclusive constitutional prerogative when deportees leave U.S. territory. See State Secrets Notice at 1, 2 RESP. At 913 Moat. To vacate March 17th HRG. At 4, 534 case 1:25, CV 00766, JB document 81 filed 0416, 25 page 35 of 46, were that true? Executive branch officials could do as they please with deportees abroad, regardless of statutory constraints that plainly apply. For example, by rerouting a plane to discharge deportees into a country where they would be tortured, even though federal law expressly forbids that outcome. See Wisha Wisha v. Mayorkas, 27 F.4th 718, 721, 22 DCCIR. 2022. The Constitution cannot tolerate that result. Even when the Supreme Court has found that an immigration statute does not apply extraterritorially, its reasoning undercuts defendants' claim. In Sale versus Haitian Centers Council, Inc., 509 U.S. 155, 1993. The court considered the legality of a program in which the Coast Guard interdicted Haitian refugees on the high seas and repatriated them. The executive order authorizing those operations relied on an INA provision that allowed the president to suspend the entry of aliens in certain circumstances, ID. At 172, quoting 8 U.S.C. 1182F, but it also gestured toward the president's constitutional powers. ID at 164 endpoint 13. The challengers urged that the operations violated a separate provision of the INA from the one undergirding the operation. ID at 170-71. The court held that the second provision did not apply to extraterritorial actions, but that was a matter of statutory interpretation. Not because any Article II powers dissolved all statutory constraints. ID at 171, 74, 177. Defendant's extravagant assertion of Article II power, moreover, runs headlong into the fact that courts regularly adjudicate, and sometimes, through their equitable powers, restrain executive branch conduct abroad. Indeed, this occurs even when national security concerns are at their apex and Article II powers robust. See, e.g., Hamden v. Rumsfeld, 548 U.S. 557, 2006. Holding executives' military commissions on Guantanamo Bay cannot proceed given their unlawful structure and procedures. Boumediene v. Bush, 553 U.S. 723, 2008. Concluding that U.S. courts retain authority to constrain executive action in Guantanamo Bay through Writ 35, Case 1. 25 CV 00766, JB Document 81 File 0416 25 page 36 of 46 of habeas corpus. In Doe v. Mattis, for instance, the U.S. military held a dual U.S. Saudi citizen in Iraq, believing him to be a member of the Islamic State. C928F.3d at 3. The district court enjoined the U.S. military from transferring him into another country's custody without 72 hours' notice. ID at 3. For after the military then provided such notice, the court enjoined the ensuing transfer on the ground that the military lacked legal authority. ID at 4. The D.C. Circuit upheld both orders, agreeing that the military had failed to satisfy the legal preconditions for such a transfer. ID at 4. 5. That courts can enjoin U.S. officials' overseas conduct simply reflects the fact that an injunction operates in personam, meaning that it is directed at someone and governs that party's conduct. In Ken v. Holder, 556 U.S. 418, 428, 2009. It therefore binds the enjoined parties wherever they might be. The situs of the violation, whether within or without the United States, is of no importance. New Jersey v. City of New York, 283 U.S. 473, 482, 1931. Steele v. Bulova Watch Co., 344 U.S. 280, 289, 1952, where there can be no interference with the sovereignty of another nation. The district court, in exercising its equity powers, may command persons properly before it to cease or perform acts outside its territorial jurisdiction, cf. Massey v. Watts, 10 U.S. 6 Cranch, 148, 158, 1810. Key principles of equity give a court jurisdiction wherever the person may be found. Mallory v. Norfolk S. Railway Co., 600 U.S. 122, 128, 2023. To argue that this court did something more than what courts routinely do, defendants must grossly mischaracterize its order and oral command. They contend that this court ordered the government to reverse an extant counterterrorism operation and deliver foreign terrorists to United States soil, RESP. At 7, CID. At 10, 11, similar, including by mandating that they turn planes around midair without regard to important logistical constraints such as Fuel 36 Case 1. 25 CV 00766, JB Document 81 Filed 0416 25 page 37 of 46 availability or foreign airspace restrictions. State Secrets Notice at 8. Hardly. The fair reading of the TRO is that it only prevented class members' transfer from American into foreign custody. See Super PP 26. 30 to be sure. In its oral command, the court said, A New York plane containing class members that is going to take off or is in the air needs to be returned to the United States, but those people need to be returned to the United States. March. 15 TR at 43. But the court made clear in the same breath, however that's accomplished, i.e., however custody is retained, whether turning around a plane or not disembarking anyone on it. I leave to you. ID. The overriding implication was therefore that U.S. officials needed to retain custody. The court thus warned that if retaining custody hinged on ensuring that planes did not take off, or turned around, or did not discharge their passengers, then such actions needed to happen, but it was up to defendants to comply however they saw logistically and operationally prudent. CJGG 2025 WL914682 at 21 Millet J. Concurring, TROs did nothing remotely like government's characterization, as they only directed immigration officials to preserve their custody, and thus the court's jurisdiction over the plaintiffs. And if the government indeed voluntarily delivered 9 passengers back to U.S. soil, see Super page 9, the choice to hold them in the United States as opposed to somewhere else was the government's, not this court's. Once the dust defendants' kick-up is cleared away, it is evident that the TRO merely did what courts consistently do: review and sometimes restrict executive actions, including when the officials are overseas, and the issues implicate national security or foreign affairs. It in no way invaded any Article 2 powers, despite defendants' effort to incant new ones into existence. In any event, even if the TRO did somehow overstep the court's Article 3 power, defendants cannot now evade a contempt charge on that basis. 37 Case 1:25 CV 00766 JEB Document 81 Filed 04/16/25 page 38 of 46B. Rule 65D. Defendants next seek protection in one of the Federal Rules of Civil Procedure. Rule 65D-1, which sets out the parameters for issuing a preliminary injunction or TRO, provides that every restraining order must: A. State the reasons why it issued. B. State its terms specifically. And C. Describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. Defendants argue that the written minute order failed to satisfy Rule 65D S requirements because it did not state the reasons why it issued, and was thus not binding upon them. And they contend neither was the oral command standing alone. See RESP at 2, 5, 9 on each point, they are mistaken. First, the collateral bar rule once again renders this entire line of argument a non-starter. As will surely be explained, the written order fully satisfied Rule 65D. But even if the written order had been deficient, it would not have been void and thus non-binding. Instead, it would have been subject to reversal or vacatur on appeal, while binding the parties in the interim. See 11A Wright and Miller, Supra. 2955. A court's failure to comply with the prerequisites in Rule 65D as to the proper scope or form of an injunction or restraining order does not deprive it of jurisdiction or render its order void. But an order challenged on appeal should be set aside if it fails to comply with the rule. Footnotes omitted. By disobeying the order rather than pursuing appellate relief, defendants cannot now rely on any nonconformity with Rule 65D as a defense to contempt. See Super PP 17. 18 to suggest otherwise, defendants cite 2 cases from the Seventh Circuit. See RESP at 5. But both undercut their contrarian proposition, as that circuit considered a failure to satisfy Rule 65D as reason either to reverse the injunction or to remand for an explanation, but not to declare the injunction void. Adkins v. Nestle Purina Pet Care Co., 779 F.3D 481, 483, 7th Circle. 2015, E360 Insight v. The Spam House Project, 500 F.3D 594, 604, 7th Circle. 2007, Defendants 38 Case 1:25 CV 00766 JB Document 81 Filed 04/16/25 page 39 of 46 argument, moreover, makes little sense. They nowhere explain why a failure to fulfill Rule 65D S requirements is a unique legal defect, rendering an injunction void rather than, like all other defects, binding but potentially reversible. Other circuits, unsurprisingly, hold the exact opposite. See in U.S. Bureau of Prisons 918 F.3D 431, 437 N.3, Fifth Circle. 2019, Test Masters EDUC Serves, Ing versus Singh 428 F.3D 559, 577, Fifth Circle. 2005, Lau versus Meta 229 F.3D 121, 123 N.2, 2 DCIR. 2000, Bethlehem Mines Corp versus United Mine Workers of AM 476 F.2D 860, 862, 3 DCIR. 1973, Bacual, for Immigrant RTS. 5. Beals, 2024 WL460, 1052, at 3 Fourth Circle. October 27th, 2024. See also Lawrence versus St. Louis San Francisco Re. Co. 274 U.S. 588, 591, 92, 1927, failure to adhere to analogous requirements set forth by statute, requiring every order of injunction to set forth the reasons for its issuance, did not render the order void, but instead meant it must be reversed. Second, in any event, the written TRO did comply with Rule 65D. Defendants assert that it did not contain any reasoning, although they acknowledge that it contained directives. RESP. At 5, they overlook, however, that the written order expressly incorporated the reasoning provided during the hearing. See March 15th Minute Order, 7:25 p.m., as discussed in today's hearing. March 15th HRG TR at 4142, explaining reasons why TRO issued. Defendants nowhere suggest that that reasoning was insufficient for purposes of Rule 65D. They are wrong, furthermore, insofar as they contend that a TRO falls short of Rule 65D if its reasoning is expounded orally in a hearing and not reiterated in the written order. Although this section of their response relies heavily on Seventh Circuit cases, they conspicuously neglect to address the one in which that court squarely held that to satisfy the requirements of Rule 65D, the explanation can be oral rather than written. EEOC Severn Trent Serves, Inc., 358 F.3D 400.
38, 442, 7th Circle. 2004, C. Dexia Credit Lock, Rogan, 602F, 3D 879, 885, 7th Circle. 2010, same for 39, Case 1, 25, CV 0766. Document 81, filed 04-1625, page 40 of 46, similar rule. See also 6 Clinics Holding Corp. 2, CAFCOMP 6, 119F 3D 393, 40001 6th Circle. 1997, similar. Defendants muster no contrary authorities. That rule makes sense, moreover, in light of the purposes behind Rule 65D. One is to ensure that parties understand their legal obligations. Into Longshoreman's Assen Vila. Marine Trade Assen, 389 U.S. 64, 75, 76, 1967. That concern is not present if the bound party, here the government, has direct knowledge of the court's reasoning, regardless of whether it was in written or oral form. Another purpose is to facilitate judicial review. Schmidt v. Lessard, 414 U.S. 473, 477, 1974. Although a written opinion is presumably better on this score, a court can review the correctness of an injunction by reviewing a court's oral exposition of its reasoning. See, e.g. 6 Clinics Holding Corp. 119F 3D at 40001. Third, even if the written order were somehow completely out of the picture, that is, if defendants were able to show that the written TRO failed to satisfy Rule 65D and was therefore void, despite no legal support for that view, a violation of the oral command itself, is grounds for contempt. The Fifth Circuit, for instance, has held that contempt can lie where, as here, the oral command was not tentative and the court made clear that it would be effective immediately. In Re U.S. Bureau of Prisons, 918F, 3D at 437 and N3. See also Malotia v. Suzuki Motor Co., 987F. 2D 1536, 1542 N7, 11th Circle. 1993. Oral orders are just as binding on litigants as written orders. United States v. Elcock, 851F. Acts 299, 302, 3D Sir. 2021. Citing ID for same. In Ray Charlotte Observer, 921F, 2D47, 50, 4th Circle. 1990. Treating oral injunction as enforceable but vacating on merits. Lau, 229F, 3D at 123 and N2. Noting Rule 65, D contemplates a written order but oral order is not void by virtue of not being memorialized, D. Indeed, consider the absurd mischief that defendant's position would license if an oral command is not binding for purposes of contempt, unless or until memorialized 40, Case 1. 25 CV 0766, Jeeb Document 81, filed 04-1625, page 41 of 46, in a written order, the enjoined party could race to accomplish the plainly prescribed act before the court could put pen to paper. In sum, each of defendants' arguments about whether there was a violation, arguments crafted for the most part as this contempt litigation has developed, are at root attacks on the TRO's legal soundness and are therefore precluded by the collateral bar rule. Even if they were not, however, they do not pass muster. The court, therefore, must conclude that probable cause exists to find that defendants violated its order. Willful, having so determined, the sole remaining question is whether such defiance was willful. See Young, 107F3D at 907. To establish willfulness, the court must determine that defendants acted with deliberate or reckless disregard of their obligations under the order. ID at 909, citing in Holloway 995F, 2D at 1082. Accord United States v. Rapone, 131F, 3D 188, 195, DC Sir. 1997. Several aspects of defendant's conduct strongly support such a conclusion. Cf. In Re Holloway 995F, 2D at 1082, analyzing whether there was willful intent properly encompasses the contemner's behavior in related incidents such as disobedience or resistance to other orders of the court. From the opening hours of Saturday, the government's conduct betrayed a desire to outrun the equitable reach of the judiciary. See Super PP2 10 JG 2025 WL102 4097 at 9 Sotomayor J dissenting. Hustling class members to an airport before the proclamation had even been published, and in the face of a suit that sought HRO was bad enough. The decision to launch planes during the afternoon hearing was even worse. The government knew as of that morning that the court would hold a hearing on whether anyone in its custody could, consistent 41, Case 1, 25 CV 00766, JIBA Document 81, filed 04-1625, page 42 of 46 with the law, be removed pursuant to the Act, and yet it nonetheless rushed to load people onto planes and get them airborne. Such conduct suggests an attempt to evade an injunction and deny those aboard the planes the chance to avail themselves of the judicial review that the government itself later told the Supreme Court is obviously available to them. See government reply in support of application at 1, Trump, JGG no. 24A931, U.S. April 2nd, 2025. Second, although defendants now seek to muddy the waters, at no point on Saturday evening, not when the court delivered the oral command directly to the government, nor at any time after the written order issued, did the government so much as hint that it was not clear precisely what action was prescribed. Young, 107F 3D at 907 N5, quotation marks omitted. After the oral command, the hearing progressed for another 5 minutes. See March 15th ARG, Tierra 4347. Although the government spoke for the majority of that time, it never mentioned, much less asked the court to clarify, the injunction just issued. CID. Government counsel has since confirmed that he understood the oral command and communicated it up the chain. See March 20th HRG at 5. Additionally, that night, after the oral injunction was relayed to the agencies, see April 3rd HRG. Tier, at 21, and as custody transfer operations proceeded, the government never contacted the court with any questions about the injunction's scope. That is telling. The government had been in regular email contact with Chambers throughout the day, and it thus knew that it would get a rapid reply to any question it might have about the injunction. Indeed, that is exactly what had happened that morning. On the email chain that included the government, plaintiffs asked the court to confirm whether the first TRO covered only named plaintiffs, and the court replied a mere 9 minutes later. Only now 42 Case 25 CV 00766. JAB document 80 Wild 04-1625, page 43-46. Does the government suggest that the court ordered something less than what it unequivocally stated in the hearing? Finally, the government plainly had an opportunity to avoid noncompliance, and yet it chose to press ahead. As previously explained, the government pulled named plaintiffs from removal flights in response to the court's first TRO, and 2 class members now aver that they were among the 9 people who landed in El Salvador early Sunday morning, but were later returned to the United States. See Supra P59. Although defendants maintain that they did not order any removal flights to return to the United States, RESP, at 4, they offer no evidence to support that assertion or discredit the first-hand declarations of class members. Taken together, this behavior indicates deliberate or reckless disregard of the order Young 107 F3D at 909, leading this court to conclude that there is probable cause that defendants willfully disobeyed a binding judicial decree. B. Next steps. So now what? The court last details the next steps that these proceedings may take. First, before initiating any criminal contempt proceedings, courts typically allow the contumacious party an opportunity to purge its contempt, that is, to remedy its violation by voluntarily obeying the court order. See Yates v. United States, 355 U.S. 6675, 1957. A court should first apply coercive remedies in an effort to persuade a party to obey its orders, and only make use of the more drastic criminal sanctions when the disobedience continues. Cf. 9A Wright and Miller, Supra 2465. The district judge normally will preface a contempt citation with an order directing either compliance with the subpoena or a showing of an excuse for the noncompliance. The most obvious way for defendants to do so here is by asserting custody of the individuals who were removed in violation of the court's class-wide TRO so that they might 43 Case 1, 25 CV 00766, JEB Document 81, filed 04-1625, page 44 or 46 avail themselves of their right to challenge their removability through a habeas proceeding. CJG 2025 WL1024097 at 2. Per the terms of the TRO, the government would not need to release any of those individuals, nor would it need to transport them back to the homeland. The court will also give defendants an opportunity to propose other methods of coming into compliance, which the court will evaluate. In the event that defendants do not choose to purge their contempt, the court will proceed to identify the individuals responsible for the contumacious conduct by determining whose specific act or omission caused the noncompliance. See Coble v. Norton, 334 F, 3D 1128, 1147, D.C. Sir, 2003. United States v. Voss, 82 F, 3D 1521, 1525, 27, 10th Circle. 1996. At the suggestion of the government in the last hearing, the court will begin by requiring declarations. See April 3rd RG TR at 2425. Should those be unsatisfactory, the court will proceed either to hearings with live witness testimony under oath or to depositions conducted by plaintiffs. ID at 2930. Plaintiffs suggesting declarations, depositions, hearings. The next step would be for the court, pursuant to the federal rules of criminal procedure, to request that the contempt be prosecuted by an attorney for the government, Fed. Crim P42A. If the government declines or the interest of justice requires, the court will appoint another attorney to prosecute the contempt. D. Finally, a note on defendant's invocation of the state secret's privilege, which permits the government to prevent disclosure of information when that disclosure would harm national security interests. United States v. Zubaydah, 595 U.S. 195, 204, 2022. They invoke the privilege as a ground for not providing certain details related to the movement of flights and class members before and after this court's TROs. Sharing such details, they assert, could make 44 Case 1. 25 CV 0766, Jeeb Document 81, filed 04/1625, page 45 of 46 foreign countries less likely to collaborate with the U.S. in the future, and would disclose means used to thwart alien enemies, allowing them to evade capture and risking the security of removal personnel. See State Secrets Notice at 4.6. See also ECF Nos. 56-2, Marco Rubio, 1013. 56-3, Christy Numdell, 10. Defendants also add that there is also no need for the information in this case, as this court has all of the facts it needs to address the compliance issues. State Secrets Notice at 1 CID. At 8, judicial review of a state secret's invocation is circumscribed but not non-existent. The government's claim is to be afforded the utmost deference, and the court must evaluate whether there is a reasonable danger that compulsion of the evidence will expose military matters which, in the interest of national security, should not be divulged. United States v. Reynolds, 345 U.S. 110, 1953, but see El Masri v. United States 479 F, 3D 296, 312, 4th Circle, 2007. T. He State Secrets Doctrine does not represent a surrender of judicial control over acts of the courts. Linder v. Dept of Def, 133 F, 3D 1723, DC Sur, 1998, describing proper examination of information's national security impact. The court is exceedingly doubtful that the privilege applies here. It is not inquiring into the diplomatic agreements that facilitated the flights nor the operational specifics of how defendants apprehended and transported class members. Instead, the court is simply seeking to confirm times and numbers, how many passengers the two flights carried, whether they were all deported pursuant to the proclamation, and when they were transferred out of U.S. custody. See Minute Order of March 18th, 2:27 p.m. The court is skeptical that such information rises to the level of a state secret. As noted, the government has widely publicized details of the flights through social media and official announcements. See Superpage 11, reposting video showing operational details. ECF No. 69. Rest to state secrets at 410, thereby revealing snippets of 45 Case 1. 25 CV 0766, Jeeb Document 81, filed 04/1625, page 46 of 46 information the court seeks, raising doubts that such information would jeopardize future diplomatic engagements or operational security. Defendants, moreover, have still not asserted that the information is even classified, and they have identified no case in which unclassified material was nonetheless protected by the privilege. Nor is the court yet persuaded that even if publicly disclosing the information might harm state secrets, sharing it only ex parte with a federal court would do the same. At this point in the contempt inquiry, however, the information at issue is not necessary to proceed, so the court will not resolve whether the invocation is warranted. Reynolds, 345 U.S., at 11 Necessity of Information, determines how far the court should probe in satisfying itself that the occasion for invoking the privilege is appropriate. But if the information turns out to be necessary later in these proceedings, the court may revisit the invocation. Conclusion. For the foregoing reasons, the court will find probable cause that defendants' actions constitute contempt. It will provide them an opportunity to purge such contempt. If they opt not to do so, the court will proceed to identify the contemners and refer the matter for prosecution. A separate order so stating will issue this day. Date April 16th, 2025's James E. Boasberg, Chief Judge 46.